Welcome to Dorsey and Whitney's webinar, M&A Update. I'd like to introduce Bryn Vaaler of Counsel and Dorsey's corporate group. Bryn?
Hello, everyone. Good afternoon. Welcome to M&A Update, our semi-annual look at corporate law developments of interest to the M&A practitioner. We're a little bit late this year with our spring edition, but that just means we've got all the more interesting things to talk about. As Rima noted, I'm Bryn Vaaler, longtime member of the corporate group of Dorsey here in Minneapolis, and my trusty sidekick, Burke, also of the corporate group, is with me today again. As usual, we'll be focusing most of our time on decisions coming out of the Delaware courts. But before we get to those decisions, we need to talk about some very dramatic changes in those courts. The last 6 months have marked the end of an era, and that's the era, Brian, of Leo Strine.
That's right, Bryn. The biggest news is that Chief Justice Leo Strine retired from the bench in October after 27 years of public service. He started as counsel to then Governor Thomas Carper in 1992 and became Vice Chancellor in 1998, rising to Chancellor in 2011 and Chief Justice of the Delaware Supreme Court in 2014. So what comes next for Leo? Well, last month he announced he would join Wachtell Lipton as of counsel, but some question whether he may be actually contemplating a return to public service.
I think that's where the smart money is betting right now. But Leo Strine has now been replaced at the top of the Delaware judicial pyramid by Collins J. Seitz Jr. He was installed late last year. Seitz, who is known as CJ, which is a pretty good nickname for a Chief Justice. He has sat as an associate justice on the Delaware Supreme Court since 2015, and CJ Seitz comes from some celebrated judicial stock. His father, Collins J. Seitz, served as Vice Chancellor, then Associate Justice of the Delaware Supreme Court, then Chancellor for 15 years before he was appointed to the federal bench, where he served on the Third Circuit from 1966 until his death in 1998. And the elder Seitz is universally known as one of the greatest jurists in Delaware history. He was responsible almost single-handedly for Delaware school desegregation in opinions that helped pave the way for Brown versus Board of Education back in the 1950s. And Brian, we've got another historic figure making a move here in the Delaware courts.
That's right. So to fill the spot vacated by Justice Seitz, Vice Chancellor Tamika Montgomery Reeves was elevated to the Delaware Supreme Court in December, having served on the Court of Chancery since 2015. She's the first African-American to sit on the Delaware Supreme Court, as she was on the Chancery Court, and she comes from a corporate law background, having practiced in corporate and securities litigation with Wilson Sonsini in Delaware and Weil Gotshal in New York. Taking her spot on the Chancery Court, Paul Fioravanti Jr. was sworn in as Vice Chancellor in February. A Delaware native, he previously was a corporate and commercial litigator at Prickett Jones in Wilmington. So we welcome Vice Chancellor Fioravanti and congratulate Justice Montgomery Reeves and look forward to reading opinions from both of them.
So some dramatic changes to the Delaware courts. And while we are on the subject of dramatic changes and developments, we would be remiss not to mention the passing of one of the greats. On October 13th, former Chancellor William Allen passed away at the age of only 71. Allen served as Chancellor from 1985 to 1997. He joined the Chancery Court at the height of the 1980s takeover frenzy. He oversaw the progeny of Smith versus Van Gorkum, Revlon, Unical. He is universally viewed as the greatest U.S. corporate law jurist of the 20th century, although it would be a mistake to think that some of the more expansive jurisprudence in terms of director liability in M&A was Allen's doing, as opposed to something he tried to reshape during his tenure. Among Chancellor Allen's most memorable opinions were the Blasius case in 1988, in which he enunciated a compelling justifications standard of review for unilateral board actions aimed primarily at limiting the stockholder franchise, the stockholder vote, and also the Caremark case, in which he enunciated the standard of liability for director oversight claims. The Caremark case was so influential that today corporate lawyers simply refer to breach of oversight cases as caremark cases. Directors have a duty of proactive oversight, but the standard of liability is extreme, bad faith, which the Delaware courts later recognized as being a breach of duty of loyalty rather than a breach of duty of care. And you know, this year at the Tulane Corporate Law Conference back in March, Leo Strine gave a eulogy of sorts for Chancellor Allen, and he summed up one of the overarching legacy points of Allen's tenure as being that disinterested directors should not be personally liable for damages for making a bad decision in M&A, so long as that decision did not amount to a bad faith act, that is, a breach of duty of loyalty, making the duty of care, in a sense, more of an aspirational goal than a potential source of practical liability. And in that sense, we can see the legacy of Leo Strine as a continuation of the legacy of William Allen. Today, in the age of Section 102b7 exculpation, the Corwin case, the Volcano case, we have come a long way from Smith versus Van Gorkum and the excesses of Revlon. And I wrote a short blog post on this point based on Chief Justice Strine's eulogy remarks at Tulane, and I'll leave you all to read it at your leisure. In the meantime, we will take a look at the legacy of Leo Strine later today, and I hope our discussion helps clarify the points I make very succinctly in the blog post. But before we look at the Strine legacy, let's take a look at two cases that really got all the headlines over the last 6 months. And Brian, the first of those two cases was the Delaware Supreme Court's reversal of the Chancery Court on the validity of so-called federal forum provisions in Delaware charters.
That's right. So before giving the case at issue here, just a little background and refresher. Claims under Sections 11 and 12 of the Securities Act of 1933 that deal with material misstatements or omissions in registration statements can be brought today in either federal or state court. Now, because of federal procedural requirements and restrictions included in the Private Securities Litigation Reform Act of 1995, plaintiffs much prefer to bring these claims in state court where those restrictions do not apply. Defendants, on the other hand, prefer federal court and the PSLRA protections. Because of this, similar to the exclusive form certificate or bylaw provisions, first authorized by the Court of Chancery in the Boilermakers decision, and later authorized by the Delaware Legislature in Section 115 of the DGCL, some Delaware corporations began including provisions in their charters providing that federal district courts are the sole and exclusive forum for private claims under the Securities Act, what's known as a federal forum provision. And in 2017, we saw a number of IPOs where the corporation had a federal forum provision in its certificate. And that takes us to the case at issue here. A stockholder of those companies, Schiabacucci, brought suit in Delaware Chancery Court seeking declaratory judgment that the federal forum provisions were invalid. And Vice Chancellor Laster agreed. He reasoned that the Boilermakers decision by then Chancellor Strine and the codification of it in Section 115 of the DGCL held that a Delaware corporation can adopt a form selection provision in its certificate or bylaws for internal corporate claims. But Strine and Boilermakers was very clear that such a provision cannot dictate the form for external claims, such as torts or contract claims, even when the counterparty is a stockholder. And Vice Chancellor Laster went on to say that a Federal Securities Act claim is just such an external claim, and therefore cannot be governed by a federal forum provision, even if the plaintiff happens to be a stockholder. So he found the provisions to be invalid, but this decision went up on appeal, Bryn.
That is correct, and the Supreme Court reversed Vice Chancellor Laster in an opinion written by Justice Vaaler. She said Vice Chancellor Laster shouldn't have limited his view by looking just at the Boilermakers case and its statutory enactment in Section 115. The relevant section of the DGCL is Section 102b1, which authorizes inclusion in the certificate of incorporation of any provision for the management of the business and of the conduct of the affairs of the corporation, any provision creating, defining, limiting, regulating powers of the corporation, directors, stockholders, if such provisions aren't contrary to the laws of this state. This is much broader, she says. Vice Chancellor Vaaler, who are reasons? Yeah, Boilermakers and its statutory embodiment in Section 115, those were limited to a pretty narrowly drawn definitional term, internal corporate claims. But the scope of Section 102B1 is much broader because disclosure deficiencies in breach of Section 11 or Section 12 of the Securities Act are within the powers of the board. A federal forum provision governing that behavior is sufficiently internal to the corporation to fall within Section 102B1. She agrees with Laster that, yeah, an ordinary tort claim or a contract claim, those would be external because no board action is present there, so they're unrelated to the corporate stockholder relationship. And then she said, as a policy matter, further, federal foreign provisions really don't raise any major concerns because as a matter of state corporate law, they've got to be approved by stockholders in order to fall within 102B1. Therefore, you've got this notion of consent, if you will, by the stockholders. And then from a federal state comity standpoint, there are no really policy concerns because directing a Section 11 Securities Act claim to a federal court, hey, they're more experienced in dealing with them than state courts anyway. So federal forum provisions are at least facially valid under the Delaware General Corporation Law, which is not to say that they will be held valid in every single application. That's the same rule basically as Delaware exclusive forum provisions. So, ladies and gentlemen, we can expect to see more federal forum provisions in IPOs of Delaware corporations going forward. And they're going to read something like this one. This is one we just lifted from the Schiabacucci case for your convenience. Brian, the other big headline case we saw in recent months was Channel Medsystems, which is another case in which a MAC-May provision failed as a way for an M&A buyer to ditch a target at the altar.
Yeah, that's right. So over the years, MAC or May clauses, even those drafted very broadly, have uniformly been interpreted very narrowly by the Chancery Court. Until 2018, no Delaware court had ever relieved a buyer from performance based on a May condition. And the background on this is the IBP versus Tyson Foods case, one of Vice Chancellor Strine's early iconic opinions, which found that the party seeking escape must show the adverse change to the company is significant, long-term, durational, and not foreseen, which is an incredibly high bar. And this was echoed in the Hexian versus Huntsman decision. Now, despite that, broadly worded May clauses continue to be used regularly in transactions. And the reason is, although they may not clearly excuse a buyer's performance, they still do have negotiation value. So if something bad does happen between signing and closing, the buyer can use the May clause as a fulcrum to try and renegotiate price or potentially even find a way out of the deal. And in fact, we saw that in the Abbott and Alear deal a few years back, which went right to the courthouse door before Abbott agreed to proceed with the deal at a reduced price.
Then along came the Acorn versus Fresenius case in 2018. We talked about that one at extreme length back 18 months ago. You'll recall that Fresenius was a German pharma company, and they agreed to buy Acorn, which was a US-based generic drug manufacturer and seller. And you recall that immediately after signing the acquisition agreement, Acorn's sales fell off a cliff. I'm using air quotes. That's a quote from the case. A huge percentage drop, completely out of whack with financial history, completely out of whack with anything competitors were seeing. And this lasted for over a year with no signs of abatement. The buyer during that period also discovered that the guy in charge of quality control at Acorn was a bad egg, and they had filed bad FDA filings with respect to multiple products. Acorn didn't investigate or remediate. It dragged its feet. Fresenius, on the other hand, aggressively investigated and encouraged remediation. Now, the result was that when they went to court, because Fresenius tried to walk away, Vice Chancellor Laster found that the straight MAC clause was triggered because of this, that the May qualifiers to the FDA reps and warranties were all triggered. He found that Acorn had not used commercially reasonable efforts to operate in the ordinary course as they had promised to do. And he found basically that Fresenius had done everything absolutely right in using its best efforts to get the deal done without giving up any of its rights. That was 246-page opinion. We're not going to go through all that detail again, talking about this new case. Let me just say you can distill everything, I think, down to 3 key aspects necessary to get out of one of these deals on a MAC. And the first was a truly serious financial drop off a cliff. Last year found, just as Brian said, IBP requires dramatic, unexpected, company-specific drop, continuing for over a year, no sign of abatement, historically unprecedented, disproportionate to competitors. Second, serious and pervasive FDA data integrity problems, and the fact that the buyer discovered these rather than the seller, that the buyer began investigation, that the buyer discovered the bad egg in QC, and the target was slow to all of this, and that Laster could look at the product sales that would be hampered as a result of these FDA problems and actually used methodology to come up with a 20% value reduction in the company. That's how he triggered those May qualifiers. And finally, this was really the case of a buyer as hero, I think. The buyer acted in a nearly perfect manner. No games, no displays of ulterior motives for wanting to get out of this deal. They really tried to get the deal done right, but it just wasn't going to happen. So, Brian, that case, you'll recall the decision by Laster was affirmed by the Delaware Supreme Court on an expedited basis. And when Brian and I concluded our discussion of that 18 months ago, we said, you know what, Fresenius Acorn is not the signal of a new lack of stringency in MAC-made jurisprudence in Delaware. Quite the contrary. It demonstrates just how ridiculously hard it is for a MAC-May to be triggered by the events and for a buyer to get out of a deal, including how flawlessly that buyer has to perform. So, Brian, frankly, Channel Medsystems had a number of factual patterns that were reminiscent of the Acorn Fresenius deal, but I don't know, I didn't see it as being that close of a case, but maybe I'm wrong.
No, that's right. The setting in Channel Medsystems is familiar. The target is a medical device company. It has problems with the FDA, and buyer tries to invoke a May clause to terminate the deal. But the facts here, as you say, are actually quite different from Fresenius. So Boston Scientific had signed a deal to acquire Channel Medsystems, which was an early-stage medical device company with one product in development, a cryotherapy endometrial ablation device, Serene, which was in the process of FDA approval. Now, similar to Fresenius, the merger agreement contained comprehensive representations and warranties permitting buyer's exit if a May resulted from the breach. Well, in between signing and closing, Channel Medsystems, the target, discovered that its VP of Quality Control was a bad egg. He had falsified third-party testing invoices and reports, which were submitted to the FDA, and had stolen nearly $2.6 million from the company.
He was a worse egg than the guy at Acorn.
Yeah, much worse. But here, Channel Medsystems immediately launches an independent investigation. They notify the buyer, they notify the FDA, and they work to remedy the submissions. So the FDA accepts their remediation plan, making it likely that Serene would still be approved on schedule. Even so, the buyer here terminated the merger agreement, claiming a breach of the reps that would reasonably be expected to result in a material adverse effect. And this goes to trial before Chancellor Bouchard. And he says, yes, there is a material breach of the reps, but there's no material adverse effect here, especially when determined at the time the buyer submits its termination notice. Furthermore, Channel Medsystems is entitled to specific performance, so the deal should proceed. Now, this ruling has been appealed to the Delaware Supreme Court, and we're waiting for that decision, but there's a few key reasons why Channel Medsystems had success where Fresenius didn't. One, there's no financial drop-off here. The target had one device that was pre-market, there was no sales yet, so all that mattered was the FDA approval process. And two, the inaccurate FDA filings were investigated and remediated in a timely manner. As a result, the FDA approval process, although slightly delayed, remained largely on track. And three, as opposed to in Fresenius, where the buyer led the investigation and remediation while still working to close the deal, here was the target that took the remedial action while the buyer focused on terminating the transaction. So this case is actually very different from Fresenius, and I think continues to show that Fresenius is an exceptional set of facts and not the rule. MAE clauses are still incredibly difficult for a buyer to invoke in Delaware courts.
It'll be interesting to see what happens if this goes before the Supreme Court, and it has been appealed, as you said. You know, that's interesting new case. The MACMA issue, of course, that everyone is obsessed about today is the COVID-19 pandemic. Is that a MAC? Is that a MAE? Is that force majeure? Can parties back out of an M&A agreement or any other kind of agreement because of this unique situation that we are living through? And, you know, that question is a really good one because experts have estimated that at the time COVID-19, mid-March, when everybody, you know, really became clear that this was going to be something huge, there were at least 150 significant M&A deals pending globally with more than $500 billion in economic value. And what's interesting, according to this study that's cited on the slide, the vast majority of M&A agreements drafted by top flight law firms don't treat, obviously, COVID-19, but they don't treat any pandemic explicitly, either in the definition of MAC, the affirmative definition, what some people call the cheese and the Swiss cheese, or in the carve-outs to that affirmative definition, the holes in the Swiss cheese, including in the traditional act of God or force majeure carve-out. They don't mention pandemic, and those 10% that do, usually they stick it in the act of God or force majeure carve-out. I'll give you an example. Morgan Stanley's acquisition of E-Trade, you can see this on the SEC's website out there on the internet, is one where they explicitly did deal with COVID-19 itself. They included it as a carve-out to the MACMA, but of course, as is usual, that carve-out is subject to a disproportionate effect override if the target is disproportionately affected by the pandemic. So we'll have to see how that comes out. Obviously, there are cases out there lined up in the courts. The first to be filed in the Delaware Chancery Court was the Bed Bath & Beyond versus 1-800-Flowers case that was filed April 1st. Many more cases being filed around the country. I just listed a few as of April 22nd, end of April. These come from the Chancery Daily. Some of you are familiar with its great online email publication about all things Chancery Court. They are maintaining, and there's a link on your slides, folks, that you can go to a public, in other words, you don't have to be a subscriber, a public page out there where they list and summarize events on all of these cases across the country. Some of these, I will tell you, there have been subsequent events you may have seen in the newspaper. The Victoria's Secret case, which is the last one listed here, the buyer and the seller reached an agreement and walked away from each other. We may see that going on here as well in other cases, but this is something we're going to have to watch as time goes on. Brian, it's May. Usually this time of the year, we're talking about amendments to the Delaware General Corporation Law, the work of the Delaware legislature and the Delaware Bar. What's cooking on the DGCL?
Well, Bryn, the Delaware State Bar Association Corporate Law Section recently recommended some relatively technical amendments, but we have no idea when the legislature will take them up or act on them. The bar suggestions have dropped the usual August 1 effective date, indicating that the typical effectiveness timeline is unlikely. So you're not missing anything here. There's just no updates to report on as of yet.
And it sounds like it's unlikely that we're not going to have anything by August 1st, the usual deadline, right? We may not have anything all year, right?
That's right.
So stay tuned, folks. Okay, we're going to turn now, as I mentioned early on in our talk, we're going to spend the rest of our time talking about various aspects of the legacy of Leo Strine, who has transformed M&A litigation in Delaware and beyond, especially in the last 5 years when he presided in the courts as Chief Justice. And it is, at least in part, as I said before, a legacy that can be seen as a continuation of that of William Allen, making duty of care more aspirational than a practical potential monetary liability source for directors who are making they're living, approving M&A deals. So we've looked at this slide before. We've said that a lot of the legacy of Leo Strine, especially in the last 5 years, can be summarized in 4 crucially important lines of cases. And just to trip through them. First, there's the Trulia case. You remember in the Trulia decision, the Delaware Chancery Court announced a strict new plainly material standard for approval of disclosure-only settlements in M&A litigation. It was an enormously important step in eliminating the M&A litigation mill in Delaware, in which minor disclosure changes were traded for large plaintiffs' counsel fees and universal releases for the defendants. Now those disclosure changes have to be, quote, plainly material. Trulia has probably done more than any other case to lessen the litigation mill in Delaware and move strike suits to other jurisdictions, mainly to date to federal courts. Second, Kahn versus M&F Worldwide, what M&A lawyers universally call MFW, the MFW case, in which the Delaware Supreme Court held that controlling stockholder M&A transactions that would otherwise be subject to entire fairness, the most stringent review, are instead subject to business judgment rule if certain procedural safeguards are in place from the very start. And the 2 principal ones are negotiation approval by a special committee of disinterested directors and approval required by a majority of the non-controlling stockholders. Third, Corwin. The Delaware Supreme Court held in Corwin that if a merger does not involve a controlling stockholder, then the irrebuttable business judgment rule applies to post-merger damages claims where there has been fully informed, uncoerced approval by majority of disinterested stockholders, even if an enhanced standard of review like Revlon or Unical would otherwise apply. And the final category of big-time changes dealt with appraisal. In the DFC Global case and the Dell case, the Delaware courts made it clear that deal price minus synergies should normally be given the greatest deference in determining fair value for purposes of Section 262 appraisal, absent clear process failures in the sales process or some incredible market irregularity. Discounted cash flow and other expert methodologies, which frequently in the past produced jackpot valuations for dissenting stockholders, those should be the exception, not the rule under Section 262, thus making statutory appraisal a far less attractive litigation route because those jackpots are going to be few and far between. Okay. We're going to focus on 2 of those lines of cases right now, MFW and Corwin, because those 2 lines of cases are closing the loop on Chancellor Allen's legacy, and because they are intertwined in a way that really I think M&A practitioners need to understand. And we're going to take you down a decision tree whereby you can analyze your cases here. So let's revisit the basics first and see how the latest cases fit into the analytical MFW Corwin scheme, starting with the law relating to controlling stockholder transactions in Delaware. Entire fairness, Brian.
That's right. So to remind you all, transactions between the controller and corporation or between the controller and non-controlling stockholders, when challenged, are governed by the entire fairness standard of review. Now, entire fairness is the most exacting standard of review and requires the controlling stockholder to prove both substantive fairness, fair price, and procedural fairness, fair dealing. The sale by a controller of its controlling interest or the entire controlled company to a third party is not governed by entire fairness unless the controller gets different consideration. Now, under the traditional Lynch doctrine, an independent negotiation structure may shift the burden of proof, but regardless of whether the defendant or the plaintiff bears the burden, if entire fairness is the standard, cases are almost never susceptible of summary dismissal, as there are almost always questions of fact for trial. Even so, entire fairness is not a death sentence, And we actually saw a case earlier this year, Koster versus UIP companies. It's not really even an M&A case. It was a stock issuance to a director, but it illustrates that entire fairness as a standard is one that controllers can prove. So UIP was owned 50-50 by two founders, and one of them died, leaving his stock to his wife. The board of the company, consisting of the surviving founder and two executives who did not own stock, over the inheriting wife's objections, that board votes to issue a 1/3 equity stake to one of the directors that did not yet own stock at a price established by an independent appraiser. So this all goes before Vice Chancellor McCormick, and after a 2-day trial, she found that the stock sale was entirely fair. Even though a majority of the board was interested, so the surviving founder gets the benefit of breaking the 50-50 deadlock between the shareholders and diluting the inheriting wife's ownership interest. And of course, the purchasing director gets the benefit of acquiring stock. So even though a majority of the board was interested, the valuation expert they hired was sufficiently independent to support a finding of both fair dealing and fair price. So you might have to go to trial, but you can still prove entire fairness. And just to drive that point home, a couple weeks ago, we actually had another case where Vice Chancellor Laster found that a private equity sponsor's actions as controlling stockholder to cause a company to accumulate cash for the sole purpose of repurchasing its shares was entirely fair. But he did so only after a 10-day trial 4 years after the action was first filed. So although entire fairness is not a death sentence, Bryn, you still will likely have to go to trial.
Yeah, it's not a death sentence, but it's very costly in time, in money, in litigation waste. 10-day trial, geez Louise. If a controller wants to avoid all that, if they want to have the basis for a summary dismissal, then they put the MFW conditions or safeguards in place from the start, or as the Delaware courts say, ab initio. And those two safeguards, as I said before, are principally a well-functioning special committee of disinterested directors and a requirement of approval of the deal by the disinterested stockholders, that is a majority of the minority stockholders. And as Brian mentioned, ordinarily the sale of a controlled company to a third party, as opposed to a squeeze out, freeze out merger, is not subject to entire fairness. It's subject to business judgment rule. But if the controller gets different consideration than everyone else, then it's entire fairness again. But SEPTA versus Volganow, another case held that MFW can be applied to that. You can get back to business judgment rule. But we talked about Olenek versus Lodzinski, Delaware Supreme Court decision last time, in which they made it clear that these conditions all have to be in place ab initio, and ab initio means before any substantive economic negotiations have occurred. And that included, in that case, sharing valuation models, even where you hadn't agreed on price. So you got to get them in place in time. But if you do, and you have those safeguards in place, yeah, then you can get your case, your entire fairness claim, turned to business judgment rule, and you can have the case dismissed on motion to dismiss. We've seen that in freeze-out settings. We've seen that in sale of controlled company to third-party settings. We've seen it in reclassification forced by a controller, and we saw that MFW body of law has moved to New York as well. So very, very valuable line of cases as far as limiting litigation. You know, Brian, the AmTrust case, a new case along this line, in a sense, it was sort of an ordinary attempt to comply with MFW that failed. But the reason it failed, I think, is kind of interesting. It's a new wrinkle, a fact situation we haven't seen before, why the special committee was not duly constituted.
Yeah, it is really interesting. So the AmTrust case involved a controller-led buyout, but the wrinkle is that the whole board of the target company had been sued in a devastating derivative claim, completely unrelated to the transaction. Yeah, 3 years before. But it was still pending at the time of the buyout. And there was actually some expert testimony out there saying that the chance of liability was high, and it could even exceed $300 million in damages. So it was against this backdrop of this pending claim that the controller attempts a buyout conditioned on the MFW safeguards, so negotiation by a special committee of independent directors and approval by a majority of the minority stockholders. And the deal ultimately goes forward. and the plaintiff stockholders here sue the officers and directors for breach of fiduciary duties. Now, the directors on the special committee moved to dismiss based on MFW and 102B7. And Chancellor Bouchard denies the motion to dismiss as to 3 of the 4 special committee directors. He found that they were interested in the sale because it would extinguish the pending derivative suit against them. The 4th director here was neutral. He had joined the board later and therefore was not a party to the derivative suit. But as a result, this wasn't a disinterested committee for MFW purposes. And furthermore, he found it was reasonably conceivable that 3 of the 4 directors acted in bad faith in approving the buyout to extinguish the derivative claims. So, at least as to the motion to dismiss, claims survive.
Wow. So let's turn then to Corwin, and then we're going to see how these two relate to each other. You know, I never tire of reminding everybody, so you're probably sick of this, that the first public announcement of the Corwin doctrine, which came 2 years before the case itself, was made by Vice Chancellor Laster when he gave the Dorsey and Whitney Foundation lecture at what was then William Mitchell College of Law. He talked about the effect that stockholder approval should have on an enhanced standard of review in litigation. He published that lecture, and that became a very important article. So Corwin says, if a merger is not subject to entire fairness standard due to the existence of a controller, then the business judgment rule standard of review applies to post-merger damages claims where there has been fully informed, uncoerced approval by a majority of disinterested stockholders. And Chief Justice Strine made it clear in the Singh versus Attenberg case that the business judgment rule in question that applies after, if Corwin applies, if you've got that approval, is a business judgment rule that cannot be overcome by showing gross negligence. It's a super duper business judgment rule that can only be overcome by showing waste. And waste is something that the courts just about never found. It was Vice Chancellor Montgomery Reeves who gave this new business judgment rule the name irrebuttable business judgment rule in the Volcano case. And in that case, she extended the Corwin doctrine to 2-step acquisitions under DGCL section 251H, where a majority of disinterested shares are tendered into the front-end tender offer by fully informed stockholders, as opposed to voted on the merger in an ordinary 1-step acquisition. And we've talked about Corwin at length in past M&A updates. We know that subsequent cases have marked the limits of Corwin. For example, we know that Corwin scrubs the M&A transaction, but it doesn't turn everything that occurred to it that was prior to it that were bad things into something covered by business judgment rules. So if the board had previously decided to ignore mine safety regulations and their mine blew up and miners died, the mere fact that they subsequently do an M&A transaction that Corwin applies to doesn't somehow scrub that earlier bad decision making. The approval's got to be fully informed. We've seen plenty of cases in which there were disclosure failures. We're going to see some more. The approval can't be coerced. So if the board of directors has 2 transactions that need stockholder approval and one is a real dog and the other one is really good, and they say to the stockholders, if you approve the dog, we will have you approve the good case, then Corwin's not going to apply to either one of those because they've used a coercive mechanism. And finally, entire fairness can't apply to the transaction because of the existence of a controlling stockholder. Corwin is predicated on finding that there is no controller. So we talked about a decision tree, analyzing your case. The initial issue in any Corwin case is there a controlling stockholder? So if we are analyzing an M&A transaction that you're doing, or looking at it for litigation purposes to see how it would be treated if litigation is brought in Delaware, the watershed question up front is, do we have a controller in the deal? If yes, then entire fairness is going to be the standard unless MFW is followed. And if yes, Corwin is not available. So time for a quick reminder. How does Delaware define a controlling stockholder? The leading case is Kahn versus Lynch Communications, the great case from the 1990s. And that held that, hey, a stockholder or a group of stockholders who own 50+% of voting power, yeah, they control. Alternatively, a stockholder or a group of stockholders who own less than that can also control if they exercise actual control of a company, or at least they exercise control over this particular transaction occurring or not occurring. And the case law making the determination under this second test is very, very facts and circumstances oriented. It's all over the map, right, Brian?
Yeah, we've previously looked at this from a percentage ownership basis, as you can see. And looking at these cases where they've found control and those where they haven't found control, it's kind of a scatter plot with stockholders or groups owning as little as 17% being found to exercise control. And that's because, as you say, Bryn, it really is a facts and circumstances inquiry, depending on things like contractual powers, veto powers, governance rights, in order to determine whether or not control actually exists.
You got to look at all of that stuff. And one of the interesting issues that comes up in is there a controller case is this matter of control groups. And the control group is, the question is, when would a group of stockholders be deemed to be a control group for Delaware corporate law purposes, thereby making the transaction a controller transaction? Whereas if these individual stockholders are not viewed as a group, none of them would individually control. And this is an interesting question, and it's interesting because the Delaware Supreme Court just produced a new leading case on precisely this point. It's called Sheldon versus Pinto. This was a case brought by a company founder against a group of venture capital investors who had approved an issuance of shares to another party that was enormously dilutive to the founders. They just got killed in a subsequent transaction. So they claimed that they brought this lawsuit against the venture capitalists, and they claimed that this group of venture capitalists is a control group, and therefore that dilutive issuance should be judged by the court under the entire fairness standard. And here's what the Delaware Supreme Court says. It said this in confirming a Chancery Court dismissal of the case. A group of stockholders exercises control collectively if they are connected in some legally significant way, such as by contract, common ownership agreement, or other arrangement to work together toward a shared goal. Connected, shared goal. Both of those things are important because there's got to be more than a mere concurrence of self-interest. And they said the strongest factor is an agreement, a contract or agreement to work toward the specific transaction in question. And based on that test, the court here affirmed a finding of no group below. These venture investors, if you looked at them as a group, they had 60+% of the voting power of the company. These venture investors had a history of co-investment with each other. They even had a voting agreement that they had all signed, but all the voting agreement did was require them to vote in favor of 3 board designees. The agreement did not require those board designees to vote in any way, and they didn't require the signatory stockholders to vote in any way on this transaction, the dilutive issuance, or anything else, just to elect those directors. So no veto power over this transaction, no sort of consultative power over this transaction. However, in order for the transaction to take place, the dilutive issuance, the venture firms all had to vote together for that issuance to amend the certificate of incorporation to permit the issuance. Notwithstanding that concerted action, that concurrence of self-interest, owning the same stock and voting together, the court affirmed a holding that there was no reasonable conceivable argument that the plaintiffs could show that these venture capitalists voted as a control group. Therefore, entire fairness doesn't apply. Therefore, case dismissed. Now, Sheldon versus Pinto analyzed 2 other important Chancery Court decisions from a few years back. The Hansen medical case, in which a group was found, and the Vanderfloot case, in which a group was not found. And I put a few bullets from those cases, very important cases to read if you are analyzing a control group situation. The Chancery Court also decided another interesting post-Sheldon versus Pinto case called Garfield versus Black, in which it found a group. And the key difference in Garfield versus Black is that the investment funds in question had a voting agreement that gave them veto power and consulting rights with respect to the reorg, which was the very transaction in question in that case. And that bound them in a legally significant way to reach a common goal. Under the Pinto test, they are a group and entire fairness applies. Okay, so let's go back to our watershed question. We said the watershed question, let's say we look at the Delaware precedent, we're confident on this watershed question that there is no controller in our transaction. So what standard of review could apply in litigation challenging our deal, claiming director breach of fiduciary duties? I maintain for our purposes, there are three possible cases. First, our transaction may not constitute a sale of control at all. For example, our transaction may be a stock for stock merger of equals between two widely held public companies, not a Revlon transaction at all, not a sale of the company. And therefore, traditional business judgment rule would apply. The only exception would be if the board of directors itself is majority interested in the transaction, then entire fairness would apply. In any event, section 102B7 would be available as an escape parachute for a director so long as they didn't act in bad faith. We're talking about in damages actions. That's number one, no sale of control. Number two, let's say there is a sale of control. If there's a sale of control, then Revlon would apply. The directors would have to satisfy the burden of showing that they'd taken reasonable steps to obtain the best value reasonably attainable for shareholders in the transaction. Again, we're assuming the board is majority disinterested, otherwise entire fairness would apply. So Revlon would apply here, except fully informed approval by non-interested stockholders makes the irrebuttable business judgment rule applicable instead. That's Corwin, my friends. And again, section 102B7 is always available to protect a director unless there is bad faith on that director's part. So sale of control, no sale of control. What if you got a sale of control and a majority of the board is not disinterested in the transaction? They're interested in the transaction. Well, as we noted, then normally entire fairness would apply. But we know from Larkin versus Shaw that Corwin is available even in that case. Not where there's a controller, but where there is entire fairness as a result of a majority interested directors. So if you get the necessary Corwin stockholder approval, again, the irrebuttable judgment rule business judgment rule can apply. But what if Corwin doesn't apply because there's some disclosure flaws? Would a special committee of disinterested directors approving the transaction, would that do some good? Would that shift the burden of entire fairness to the plaintiff under traditional Lynch, Conn versus Lynch doctrine? Or would it shift the standard of review to something other than entire fairness? I note these questions because we've got cases freshly decided in each of those three categories. We'll come back to that, but first, another note. You noticed in all these cases, in fact, even in the controller setting that Brian talked about, section 102B7 exculpation protects individual directors from monetary liability in a post-closing damages claim, so long as they have not themselves breached their duty of loyalty by being interested in the transaction or profiting from the transaction, or acted in bad faith, because duty of loyalty, bad faith, those are exceptions to 102B7 exculpation. That notion that I just told you, this parachute for each individual director so long as they're disinterested, acting independently, and not acting in bad faith has become known in Delaware among Delaware litigators as the Cornerstone Doctrine, named after Cornerstone Therapeutics case in which the Delaware Supreme Court affirmed a plaintiff seeking only monetary damages must plead non-exculpated claims against a director who's protected by an exculpatory charter provision to survive a motion to dismiss, regardless of the underlying standard of review for the board's conduct as a whole, be it Revlon, Unical, the entire fairness standard, or the business judgment rule. In other words, in the face of a 102b7 exculpation provision, in order to succeed in keeping a director in fiduciary duty damages claim, the plaintiff has to show the director was self-interested, lacking in independence, or acting in bad faith, regardless, as I said, of the standard of review applied. And remember, one thing important in Delaware, section 102b7 exculpation applies to directors, but as we're going to see in a minute, officers aren't covered by exculpation. So, Brian, with that, assuming no controller, let's look at our three categories we just said. No controller. We said the three categories. The first is no sale of control, so it's governed by traditional business judgment rule, right? We had one of those cases recently. Towers-Watson was the name of it.
That's right. So the Towers-Watson case was a classic stock-for-stock merger of publicly held equals with no controllers and majority of independent boards. After the deal closes, shareholders bring damages claims against the Towers board for breach of their fiduciary duties. Vice Chancellor McCormick dismissed the damages claims against the board based on the business judgment rule and 102b7. She says, I don't need to get to the Corwin issue. There's no sale of control here, so the standard of review is just the traditional business judgment rule. But she then goes on to cite Corwin anyways and says, well, because there was fully informed shareholder approval, you plaintiffs will have to show waste to overcome instead of just gross negligence. So in essence, Bryn, the fully informed shareholder vote here kind of transformed it from the traditional business judgment rule to the irrebuttable business judgment rule.
Interesting, but you didn't have to get Corwin approval in order to get to the business judgment rule of some type. You know, we had a couple of cases, Brian, illustrating category 2. Remember, category 2 was sale of control. So Revlon enhanced scrutiny would apply unless Corwin intervenes. And the first one was a case we talked about in an earlier setting a couple years ago called Morrison versus Berry. So this was a case in which there was no controller, no control group, and the company that was being sold is called the Fresh Market. And the founder of that company was a guy named Ray Berry. And he wanted to sell the company to the Apollo Private Equity Group, and he and his son were going to roll over their 10% joint interest in the equity of the company and stay involved in the management. So this is a classic MBO financed by private equity money. And the stockholders sued Berry and the rest of the board and the officers for breach of fiduciary duties in agreeing to do this transaction with Apollo, seeking damages. Now, the transaction was approved by stockholders and closed, and the Chancery Court had dismissed this claim, the Revlon claim, arguing that Revlon was no longer the standard of review. It had shifted to the business judgment rule because of fully informed stockholder approval of the sale to the Apollo Group. And that case, you'll remember when we talked about it before, was overturned by the Delaware Supreme Court because Justice Vaaler reasoned that there were lethal disclosure problems in the tender offer disclosures relating to Berry's, pre-existing agreements with Apollo and how those undermined the sale process. Therefore, the standard of review in this case was Revlon. They overturned the motion to dismiss below. But interestingly, she did not deal with the possibility of dismissal under Cornerstone and Section 102b7. So that issue of dismissal is raised by all the defendants to the case, and that goes back down in the current case that we're talking about before Vice Chancellor Glasscock. on cornerstone motion to dismiss under section 102B7, regardless of what the standard of review. And Glasscock says, just like I said, although Revlon applies to the underlying company sale process, this does not change the requirement that the plaintiff plead a non-exculpated claim. For fiduciary duty claims to survive against the defendant, director, plaintiff must plead allegations that the director was either self-interested, lacked independence, that would invoke duty of loyalty, or acted in bad faith. That's bad faith. So to state a claim for bad faith in the context of disclosure, Glasscock says the plaintiff must allege the director defendants knowingly and completely failed to undertake their responsibilities. And based on that body of law, Glasscock dismisses claims against all the directors except Barry. Barry being clearly not disinterested. He was clearly interested in the transaction because of the rollover aspects of the MBO. And he says the plaintiff states a claim for breach of duty of loyalty against Barry, so he stays in. Notice lawsuit was also brought against General Counsel, who was an officer but not a director. Therefore, he is not dismissed in this case because 102B7 doesn't reach him. Cornerstone doesn't reach him. The standard for him is duty of care, gross negligence, possibly a duty of loyalty claim because he also had some transaction triggered by the transaction. Same is true with the CEO, both officer and director. As a director, his actions, it's dismissed, but we have to see what his actions were as an officer separate from being a director. So, Brian, it's a beautiful illustration of the Cornerstone Doctrine in action. And Brian, the Essendant case kind of illustrates that same point. Another brand new case.
Yeah, that's right. So the Essendant case involved a sale of office supplier Essendant in a two-step cash transaction with the PE firm Sycamore, or a cash offer followed by a merger. So it is a sale of control, so Revlon applies unless cleansed by Corwin. Now, post-merger damages claims are brought, claiming that Sycamore is a controller and that there's material flaws in the tender offer disclosure. Defendants here try to move to dismiss under Corwin and under Cornerstone 102B7. And Vice Chancellor Slights dismisses all the claims. First, he says Sycamore is not a controller. They only have 11% ownership. There's no other governance rights. So Revlon applies unless cleansed by Corwin. And second, he said that he didn't actually even need to reach the validity of the Corwin defense here because regardless of the standard of review, plaintiffs have not alleged disclosure or other process or substantive fiduciary breaches that would make a finding of bad faith or waste reasonably conceivable. So everyone gets off based on 102B7 and Cornerstone.
Finally, just a quick look at category 3. We said that was no controller, sale of control, but this time, unlike the last two cases we talked about, a majority of the board is not disinterested. Therefore, entire fairness is the standard, but we ask the question, what if there's a special committee involved? What does that do to the transaction? The case is called Salladay versus Lev. Intersections Inc. was the target, and it had 6 members on its board. 3 of them had big equity stakes. They also had big debt investments in the company. Companies pressed for cash, looking for a buyer out there, and they find a buyer group, the I Subscribe group, and that I Subscribe group says, we are willing to buy the company for cash. We'll make a major debt infusion into the company, but you 3 guys with big investments, and you're not controllers, but you got to make a rollover in this thing and come out of it with us. So Intersections forms a special committee consisting of the other 3 directors, the guys who don't have a big equity stake. They hire financial advisors and counsel, and they canvass other possible buyers. Special committee negotiates $3.68 per share in cash, plus a $30 million infusion of new debt financing for the company. The full board approves the transaction negotiated by the special committee. The 3 directors roll over, and the stockholders approve the transaction. It's a tender offer transaction. And stockholders bring fiduciary duty claims against all 6 directors seeking damages. Transaction closes, and the directors move to dismiss. And immediately, the plaintiffs drop claims against the 3 special committee members, the guys who didn't have an interest in the transaction. Why did they do that? Well, they dropped the claim voluntarily because of section 102B7 and Cornerstone, because no matter what standard applies to this, all the way from entire fairness to business judgment rule, those guys have got a 102B7 parachute. Now, as to the other three interested directors, the guy who rolled over their stakes, very interesting here. Motion to dismiss by them is denied. Glasscock says there's two ways standard of review could shift to burden to business judgment rule, as opposed to simply shifting entire fairness from one party to the other. One is Corwin, fully informed stockholder approval or tender offer. Not applicable here because there were plausible allegations that there were disclosure problems in the tender offer documentation. But here's what's new or newish. He says I can also change that standard of review with fully informed approval by a special committee of independent directors. But I'm not going to do it here because the directors came in after the special committee came in after substantive economic negotiations had already occurred. And in order for special committee to have the effect of shifting the burden of proofs, you've got to meet the same ab initio requirements as an MFW. He's just making this up, folks. Nevertheless, in this case, he says entire fairness remains the standard of review and the motion to dismiss is refused. So this is new law. This is making new law. Under traditional Lynch doctrine, an effective special committee would have simply shifted the burden of entire fairness to the plaintiff. But the dictum in this case, citing dictum in Trados 2, an important Laster decision, and in Voigt versus Metcalf, we've got another decision in which Laster holds the same thing, again in dictum. So the next time this comes up, and it's for real, and it could make a difference in the case, you got 4 or 5 cases in which dictum supports what you're doing. New law in the making. Brian, let's just finish up for 30 seconds here. We got a couple new appraisal cases that we just want to quickly note after the Dell and DFC line of cases.
Yeah, that's right. So this really dealt with Leo Strine's legacy on how fair value is determined in an appraisal action. And the thrust of the DFC, Dell, and Versian decisions that we've discussed over the last few years is that in most cases, the court ought to adopt a market-based valuation, which typically will be deal price, unless there are flaws, minus synergies to the extent that can be reasonably estimated. And we saw a few new appraisal cases this time around which echo those points. Stillwater Mining Co. is a straight deal price case. Manishing Capital, on the other hand, found flaws with using the sale process and therefore used discounted cash flow as the most reliable tool for determining fair value. And in Panera Bread, Vice Chancellor Zern used deal price minus estimated synergies to arrive at a fair value of $303 per share. But what's interesting here with this last case is that Panera had already prepaid the dissenters the $315 deal price to cut off the accrual of statutory interest, which is 5% over the federal funds rate, pursuant to Section 262 of the H of the DGCL, which, as you'll recall, was amended in 2016 to allow this. And Panera said, well, since we've overpaid, we'd like our money back. And Vice Chancellor Zern held that the stockholder is not required to reimburse the excess of prepayment over fair value under Section 262H. We've pointed out before that Section 262H is silent on this, but the result here is not surprising and is in line with treatment under the Model Business Corporations Act. So the takeaway, Bryn, is if you prepay, you get the benefit of cutting off interest, but you do not get a reimbursement if fair value is determined to be lower.
Folks, we are all out of time. I'll let you read the housekeeping slides, but I instead want to thank you for joining us. I want to thank Brian Burke for his partnership over the years. It has been my great pleasure and privilege to do these M&A update presentations for Dorsey lawyers, for our clients, and for our friends, now for more than 20 years. This will be my last one. I'm retiring at the end of June, but Brian and company will keep you up to speed in the future, and I look forward to hearing about the latest Delaware cases and other M&A developments from a comfortable seat along with you in the audience. Thank you, ladies and gentlemen, and goodbye.